Okay. Appears our clocks have not been fixed here, but according to this, it's 6:02. I think it's 7:02, so we'll get started. All right, so I'm going to go ahead and call to order the meeting. The March 14th meeting of the Rent Control Board is called to order. Would the secretary please take the roll?
Commissioner Foster.
Here.
Commissioner Duran.
Here.
Commissioner Trosas.
Here.
Commissioner Phyllis. And Commissioner Sultan are missing, or absent, I'm sorry, they're missing.
They're absent
Missing
today.
when presumed okay.
They're okay.
Yes.
So seeing that we did not have a closed session, we'll go ahead and start in a salute to the flag. Please join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, so do I have a motion on the floor to approve the minutes from the last board meeting?
Since Steve wasn't here, but I was, that's only two of us. Can we do it with two?
To take action, you need three. This isn't really action, but in any event, there's no law that requires a member to. Members normally do abstain from voting on the approval of minutes, but there's no reason
So
why
Steve
they
can
must.
vote.
Yeah.
I move to approve the minutes.
I'll second that. Could we
Voice vote.
just do a voice vote? All in favor say yeah. Aye.
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 All opposed? All abstaining? Okay, we'll move forward. All right. Special agenda items. We have some brief announcements, I think, from our executive director. We'll go ahead and take these.
Yes, good evening. I just wanted to mention two things tonight. The first is that since your last meeting, we hosted our Owning Rental Property in Santa Monica seminar. We had a good attendance, more than 40 people were there. Their comments afterwards indicated that they felt they had gained valuable knowledge and that the presentation was well organized and thorough. So I wanted to thank Mr. Costello and Beth Laderpack, who presented that seminar.
Fabulous.
And then I want to mention that this in April is Fair Housing Month, and the City Attorney's Office always offers a workshop on fair housing. And like last year, we're participating in the planning for that, along with Santa Monicans for Renters' Rights, the Apartment Association of Greater Los Angeles, and the Action Apartment Association. That will be, on Tuesday, April 23rd, from 9 to noon at the Santa Monica Main Library. It's a great opportunity for people to learn about issues related to fair housing, and this year there will be panels on basic issues related to fair housing, gentrification, the Section 8 housing program, and disabilities. And all property managers, tenants, advocates, and attorneys are invited to attend, and they can RSVP and sign up by either checking our website or the city attorney's website. So as I said, that's 9 till noon.
Can I ask a question? Is there going to be information there about how individuals might be able to get on our consolidated wait list for the Section 8 housing?
She will talk about the wait list for Section 8. It's not open all the time. Right. Certain people are able to be put on the list, like people who are evicted through the Ellis Act or for owner occupancy. The City Council has adopted a preference for those people, so if that happens, they are able to go onto the list or at the top of the list. Otherwise, they open it periodically. But it is, there's an effort being made to consolidate all of the waiting lists for the various programs, so that's something that the city will be working on this coming year, and I'm sure she will talk some about the waiting list.
Fabulous. Thank you for that information. Appreciate that. All right, public comment. I don't believe we have any public comment unless any individuals here would like to submit a late chit. This is the time set aside for members of the public to address the board on matters not included on the agenda. We don't have any public comment. Okay. Moving forward to the consent calendar, I don't actually see. You said that there was a comment on the consent calendar, but I don't actually see any comments. Okay. So 9A, property owners, ENA 1 LLC and ENA 10 LLC. Do we have to go ahead and actually?
I move to accept the pass the
Thank
consent
you.
calendar.
I second that. Do we need to take a voice vote or a roll call? Okay, thank you.
Commissioner Duran,
Yes.
Commissioner Foster,
Yes.
and Commissioner
Oh,
Trosis.
Yes.
Motion carries.
Thanks. Okay, jurisdictional items. We're moving on to 10. We have 10A 1, owner occupancy exemption at 1787 424 Ocean Park Boulevard. Applicant R. Kolodziej. I'm so sorry. Do we need to have any sort of staff report on that?
I'd like to hear one if I can.
Okay. Okay, go ahead with the staff report.
Commissioners, this is regarding the property at 424 Ocean Park Boulevard. The exemption was filed by Mr. Ronald Kolodziej. He bought this 3-unit property back in 2007 and states that he most recently moved onto it back in August of last year.
Okay.
He's applied for to exempt it as an owner-occupied property with 3 or fewer units. He's the sole owner, and the number of units on the property both satisfy the percentage ownership requirement and the unit requirements for an exemption. The question before you is whether he's lived on the property as principal residence since at least August 20th of last year, which is 120 days prior to the filing of the application. He submitted utility records, bills, financial records, and government records that show he has used the property as his mailing address during this period. He owns a property in Culver City where his ex-wife lives and where he uses the garage as office and storage for his construction business. The voter registrar shows the property as the property before you as his address. The DMV and the Santa Monica Water records show the Culver City address as his mailing address from a previous residence there. Mr. Kolodziej explained that he has not yet updated the DMV and he hasn't updated the water company because he pays his bills online. The other units on this property are rented by tenants. Both units confirm that he lives on the property. Because the preponderance of the evidence in the record shows that Mr. Kolodziej has met the requirements for the exemption, staff recommends the board grant this application and adopt the findings of fact and conclusions of law which are attached to the staff report.
Okay, I do not see any sort of public comment on this. Do we have any comment from our commissioners?
I will move to grant the motion or
Accept the staff report.
accept the staff report and the findings of facts, conclusions of law.
Second.
Okay, can we call for a vote?
Commissioner Foster,
Yes?
Commissioner Duran,
Yes.
Commissioner Trosis.
Yes.
Motion carries.
Chair, if I could.
Sure. Go ahead.
As we were mentioning last month, when these things are straightforward, they're straightforward. And the staff has done a great job of, hearing the case and researching the case, and they've all concluded that without any shadow of a doubt, these are uncontested exemptions. And I would propose that we accept the next two
Okay.
to grant.
So we have a motion on the floor to grant the exemptions and adopt the findings of fact and conclusions of law for 10A2 and 10A3. I would accept that because there are no public comments on these matters. They're not contested, and the facts are fairly straightforward, although I will say that we do not take owner occupancy exemptions lightly. This is statutory, however, and I feel that that's a warranted motion. Do we have a second? Did I second that?
I think you did.
Okay, great, fabulous. Yeah, sure, go ahead.
All right. Yeah, to your last point, I do feel that they are serious, and that's why I would like to give them their due attention, at least for no other reason than to make it public record so that it's heard over the airwaves. Do they still call it airwaves? I don't know. Anyway, but I do understand both of my colleagues' point, and I'm willing to agree to that. So that's fine.
Okay, so we have a motion and a second. Can we call for a vote?
Commissioner Duran,
Yes.
Commissioner Foster,
Yes?
and Commissioner Trosis.
Yes.
Motion carries.
Great. Okay. Moving on to jurisdictional items 10B1. We have, I'm sorry, I lost my agenda here. We have an appeal at 1124 15th Street, Unit E. Landlord is appealing the hearing officer's decision granting a rent decrease for a reduction in housing services. May we please have a staff report?
Certainly, Commissioners. The hearing officer in this case awarded rent decreases to tenant Ben Youssef in Unit E for a damaged screen door and because his landlord, Ms. Shu, had been parking in his space and had also instructed workers to park there as well. Visitors, including Airbnb guests on the property, appear to have also been using that space. Ms. Shu and Mr. Xie have appealed the decision, but they have done so and they're the landlords, and they have done so in an untimely manner. The board may only consider the appeal, therefore, if the board finds good cause for the late appeal. The owners argue that the appeal is late because they didn't receive the decision until the 10th day, which is when the appeal is otherwise due. The decision, however, was sent to the property at Unit F, which is the address Ms. Shu used to sign in at the hearing, and is also the address that Ms. Shu specifically asked the hearing officer to send the decision to. Apparently, Ms. Shu lives in the Inland Empire. The owners therefore appear to lack good cause for the late appeal, and staff recommends that the board reject the appeal as untimely. Substantively, the owners ask the board to reverse the hearing officer's decision because they have hired a new management company and claim to have fixed the screen door, and state that they will no longer be visiting the property, so they won't be using that space inadvertently, the parking space. But that they may have fixed the screen door or that they are no longer using the parking space of the tenant does not prove any factual or legal errors in the hearing officer's decision. Instead, there are potential basis for a request for compliance, which the owners have filed in this case. Staff therefore recommends that first, and this is what you'll have to first decide, is that the board reject the appeal as untimely and without good cause. And if the board nonetheless finds good cause to accept the late appeal, staff recommends that the board affirm the decision because the owners have failed to prove or even state a basis for reversing the hearing officer's finding.
Thank you for that. Is the appellant here? Does the appellant want to
Didn't put in a show.
speak to why they filed an untimely appeal? Okay, does not appear that they do. Commissioner Foster?
Yeah, so in my 3 years on the board, we have occasionally accepted a late appeal, and they're for good, solid reasons. So for the public's benefit, I think it's important to understand that things that would constitute a good reason would be a death in the family or a medical emergency or out of the country, so things like that that are unavoidable. Simply confusing an address when you know you're about to be in receipt of something important is, in my opinion, not grounds for anything resembling an extension of the appeal date. So I'm going to be voting in that way.
Commissioner Duran? No comments? Okay.
I would move that we
Right.
accept the staff's report to reject the timeliness of the appeal on its face and uphold staff's decision.
Okay, thank you. And I would second that and also just add that I generally tend to err on the side of inclusion and kind of willingness to hear from appellants. But in this case, I think it's pretty clear that this was not a legitimate reason. So I too believe this is an untimely appeal and therefore will reject it, vote to reject it. So I don't know. We have a motion and a second. Can we call for a vote?
Commissioner Foster,
Yes.
Commissioner Duran,
Yes.
and Commissioner Trosis.
Yes.
Motion carries.
Okay. Moving on to A2 at 1809 Euclid Street. The appellant, applicant is Heron, S. Heron. Can we have a staff report?
What I don't.
What?
We're on to the back page.
Am I hallucinating? I'm so sorry. I literally was reading from the wrong section. My apologies.
No problem.
Moving on to administrative items, 12A. Do we have a staff report?
Yes. The board issues rent decreases as part of its core rent control function, recognizing that if a unit's maximum allowable rent remains unchanged even while housing services or maintenance are reduced, that rent has become unfair. The board therefore lowers the maximum allowable rent to a level commensurate with a lower level of maintenance or services, so that the rent again becomes fair. Under the board's current practice, rent decreases do not account for any period of reduced maintenance or services leading up to the day when the rent decrease goes into effect, even though for a decrease to go into effect, the reduction in services or maintenance necessarily preceded that date. This necessarily leaves a period of unfair rent unremediated because for the board to award a rent decrease, the tenant must complain to the landlord in writing about the reduction in services or maintenance at least 30 days before filing the rent decrease petition. Then the complained of problem must still be in existence on the date of the hearing. By the time the decision reducing the rent goes into effect, the rent may have been unfair for several months. Staff understands that it was to address this problem that the board initiated this administrative item, instructing staff to propose approaches to calculating the period covered by a rent decrease that would account for more of that period. Staff has proposed 3 such approaches. The first is calculating a rent decrease from the date when the reduction in services or maintenance began. The second is calculating it from the date when the tenant filed a rent decrease petition. And the third is calculating it from the date when the tenant served the landlord with written notice of the problem on which the rent decrease petition is based. Turning now to the first, which is again calculating the decrease from the date when the reduction began. In the abstract, there are sound arguments for calculating a rent decrease from the date when the problem on which it is based began. As noted above, a decrease that accounts for only periods long after the unfairness in the rent began, does not fully remedy the problem at which the rent decrease process is aimed. But there are public policy reasons why restoring rents to the commencement of a problem may be unwise. Historically, the board has pursued a policy geared more toward encouraging compliance with the law than imposing remedies for its noncompliance. Its guiding principle appears to have been that it is preferable to administer the law in a way that encourages owners to quickly fix problems that could lead to a rent decrease than to focus only on providing a remedy for when they fail to do so. Under the board's current practice, for example, a landlord may avoid a rent decrease altogether by fixing a complaint of problem before the hearing. The board's historical policy of favoring compliance over remedies for noncompliance is further demonstrated by Regulation 4003, which requires a tenant to notify a landlord of a claimed problem warranting a decrease and give the landlord the opportunity to fix it before a decrease petition may be filed. That regulation also requires the tenant to act on that notice by initiating a decrease petition within 6 months if the problem is not corrected, ensuring that the tenant is motivated to push the landlord's compliance expeditiously rather than sitting on his or her rights. If not limited in some way, a requirement that a rent decrease be calculated from the date when the problem giving rise to it began would undermine this long-standing compliance-encouraging policy. A tenant who stood to benefit from a rent decrease compensating him or her for a problem's entire duration, no matter how far back its genesis, would have no incentive to see that that problem was promptly resolved. If anything, he would have an incentive to do the opposite, to game the system through delay. He could allow the problem to go unremarked upon for months or even years before notifying his landlord, wait the full 6 months after giving a notice before filing a petition, then take every opportunity to delay and postpone the proceedings and thereby achieve a windfall of discounted rent. To avoid creating such perverse incentives, staff does not recommend this approach. The second alternative, again, is to calculate the rent decrease from the date when the tenant filed the decrease petition. Doing this would avoid the pitfall of creating a disincentive for tenants to act diligently. It would also have the virtue of simplicity and ease of administration, but it might not achieve the goal that the board expressed the desire to explore. That goal, again, is to calculate rent decreases to account for a period during which the tenant was required to pay a rent that had become unfair due to the reduction of maintenance or services. As noted above, a tenant cannot apply for a rent decrease until she is first given a written notice that allows the landlord the opportunity to correct the problem. Even the most diligent tenant who gives the landlord written notice the moment that the problem arises and files a decrease petition on the 31st day thereafter if the problem isn't corrected will have been paying rent that by definition has become unfair for at least a month. The reality is that most tenants are likely to try to work things out with their landlords informally by simply talking with their landlords, such that weeks may pass before they finally put their complaint in writing. Many tenants do not file their decrease petition on the 31st day after giving their landlord written notice. 2 or 3 months could pass between the date when the landlord first became aware of the problem and the filing of a decrease petition. To calculate a rent decrease only from the date when the petition was filed would certainly take into account some of the period during which the rent had been unfair, but only a portion of it, and in most cases a great deal less than the period during which the tenant's rent remained unfair through no fault of the tenants. This unfairness would be compounded if before a rent decrease could go into effect, the landlord finally corrected the problem on which the decrease was based. Under the charter, rent is restored retroactively to the date that the correction occurred. Just as calculating a decrease from the date when a problem first arose would provide a perverse incentive for a tenant to engage in dilatory tactics, calculating it only from the date of the application could do the same for landlords who might have an incentive not to correct a problem, which economically benefits them at the expense of the tenant from whom they are collecting an unfair rent, until the administrative process has yielded a formal rent decrease. Because by correcting the problem before that decrease goes into effect, the landlord could collect unfair rent for months, secure in the knowledge that he or she would never be required to make the tenant whole. The third alternative is to calculate the decrease from the date when the tenant gave the landlord written notice of the problem. The problems of the first two approaches can be mitigated by calculating a rent decrease from that date. This would give tenants an incentive to inform landlords promptly of any claimed problems, but would not divest them of the ability to be made whole purely as a result of the length of time that it takes to reach the outcome of the hearing process. But to ensure that this approach would be fair to landlords and tenants alike, it should include some limitations. First, there should be a limitation on tenants' ability to artificially lengthen the period from which any decrease is measured by delaying the time before they file a petition. This could be done by providing that a decrease is calculated from the date of the tenant's notice to the landlord, but only if the tenant files a decrease petition within 60 days of giving that notice. This would make the decrease process mirror the rent restoration process, under which the rent is restored to the date when the problem giving rise to the decrease is corrected, but only if the landlord applies for the rent restoration within 60 days of that correction. Second, there should be a limit on landlords' ability to divest tenants of the opportunity to be made whole by waiting to restore services or maintenance until after a rent decrease is ordered. This could be done by providing that a decrease accounting for the period before a decision is awarded may be taken regardless of any subsequent resolution of the problem on which the decrease is based. A landlord would still have an incentive to act promptly to correct the problem to prevent the decrease from continuing. And if a decrease will occur regardless of subsequent repairs, the landlord also has an incentive to correct the problem as quickly as possible, to limit the amount of any decrease corresponding to the reduction of services or maintenance determined to have existed before the hearing date. This approach's greatest drawback is that it may prove complicated to administer, especially in cases in which a tenant gave the landlord notices of different problems on different dates. Because this approach subsumes but alters portions of the other two, staff has drafted proposed regulatory amendments for this approach only. Those amendments are included as a proposed new regulation 4203, which is in the appendix to the staff report. That appendix also includes existing regulation 4004, to which no changes are recommended for the board's reference. Should the board wish to pursue either of the two approaches, or one that staff has so far not thought of, the draft regulatory amendments can easily be redlined to reflect those changes. It is possible that this new approach will affect parties' willingness to engage in mediation, though whether it would make them more likely or less likely to do so, it is difficult to say. It's also possible that a new approach, whether this one or another, will have other effects not currently contemplated. It is for this reason that the board should first consider this subject after hearing from the public as part of this administrative item before staff drafts a final proposed regulation for the board's consideration at a subsequent public hearing.
Oh, sorry, keep going. I'll ask
Okay.
again.
Staff recommends that the board decide upon an approach, if any, whereby rent decreases may take into account reductions in services or maintenance occurring before a decision is issued, and direct staff, as appropriate, to return at a subsequent meeting with a proposed regulation for adoption after a public hearing. Thank you.
So are you saying that alternative two, which is calculating the decrease in the date when the tenant filed the decrease petition, incentivizes landlords to delay their repair? Is that what you're asserting here? Because of the 30-day waiting period? I'm just not following that. I mean, because isn't it just like 30 days period?
Well, a rent decrease doesn't go into effect at all if the problem's fixed before the hearing date. Moreover, even if you go through the entire hearing process and there is in fact a decrease, and then within the next 60 days the landlord fixes the problem, the restoration will be retroactive because of the charter's provision to the date when the repair was done. that would incentivize landlords to just wait to see what the outcome of the hearing was, because they really have no incentive, since they're never going to suffer a rent decrease, until the hearing process is done.
Yeah, but in this situation, aren't we saying that theoretically, if we grant rent decrease, it's from the date that they filed the petition? So I don't know. Maybe I'm just totally dense, but I don't know that I'm really agreeing to that assertion. I don't know.
Okay, well, it's worth.
No, it's
thinking.
fine. I mean, I'm not completely clear that incentivizes a delay, but maybe I'm not understanding exactly what the reasoning is.
Okay.
And then we, just as a kind of process question, when the tenant first gives written notice to the landlord for the opportunity to correct the problem, are we at that point requiring them to notify the landlord of mediation services available to them? And is that something that we could do?
We don't require the tenant to do that, but we contact the parties ourselves in every case.
Once that written notice has
Once
been
a
given.
petition is filed. Once a
So
petition is
yeah,
filed.
but I'm talking about before they file the petition. Is there a way that we can offer mediation in advance of a petition so that we could kind of mitigate some of this?
You'd have to educate every tenant in town
I
ahead of time. That'd be tough.
It may be that's not this.
Yeah, I know. I was just asking. 'cause I
There are
wasn't
reasons
sure.
why I think that that's not a good idea.
Okay.
But that's not this item, so
Yep.
we should.
Okay.
yeah.
Just asking. All right. Any other questions before we go to the comments? Okay. Yes, there are. All right. So 12A JL Jacobson. We have 3 minutes, correct?
J.L. Jacobson, 2812 Santa Monica Boulevard. Tonight, if you look on the agenda, you'll be deciding rent increase petition 5096. And next month, rent control will be in effect for 40 years. I think it's amazing that you're finding that they've been doing rent decrease petitions wrong all these years. And I think that if you go and try to do this regulation, you will find out about the history of rent decrease regulations. Now, your staff report points out, it cites in the footnote Sterling versus Santa Monica Rent Control Board, but it doesn't discuss it at all. This is what it says at 25 Calat 4th, 1053. Quote, now for a while, you couldn't do any rent decrease petitions. You weren't here. I was here in 1984, okay? And for a while, the board was out of the decrease petition business entirely because it was adjudicating, and basically it was awarding damages. Now, this is what the court said. Contrary to the view of the Superior Court, there is not any question in the instant matter of an unconstitutional exercise of judicial power or the awarding of damages. In all cases, respondents, that's you, determinations are prospective in nature. Tenants are not authorized to withhold rent as compensation for the landlord's failures. Respondent's hearing officer makes a factual determination on the evidence of the appropriate maximum allowable rent to be charged in the future only. I'm surprised with the number of attorneys on this board that nobody knows that there's no such thing as a retroactive rent adjustment. You know, and another thing is that if you want to go and give damages for past things, you should read section 1809 of the rent control law instead of 1803, which is about rent adjustments, because the only way that you can award damages is if a landlord collects rent in the amount by which the payment or payments demanded, accepted, received exceeds the maximum lawful rent. That's said in two sections of 1809. So you can award damages if the landlord accepts more than the maximum allowable rent. You can't go back in the past and go giving damages for that, or you're exercising judicial powers. Now, finally, I think that you should think about it. You know, tonight, the decrease petition tonight went into effect on March 1st, even though it's the 14th. Rent decrease decisions go in effect immediately. But under McHugh, if you award damages, you can't put them into effect immediately. You have to give the owner an opportunity to seek a stay order, which means at least 30 days. So if you want to award retroactive damages, and again, it's beyond me how you could think of such a thing. There is no such thing. In fact, if you want to check it out, you should. I also advise you to read the decision of Larson versus Larson versus City of San Francisco Rent Stabilization Board, which does an excellent job of reviewing McHugh and says why you cannot collect retroactive damages.
Okay, Mr. Westcott, you have 3 minutes.
Okay, I'm going to start out by reading a small part of a letter that was written during my rent reduction hearing after there were a lot of delays, and it's my opinion that the delays were intentional because the owner knew that I was going to get a rent reduction, and the longer it was delayed, the less, he would have to reduce the fewer months he'd have to reduce my rent. So there's a letter that's dated February 9th, 2016, where the hearing officer said that the attorney has not explained his failure to contact the hearings department in advance of 2 of his non-appearances. And in the decision, I think it was on April 28th, 2016, the hearing officer wrote, "Respondents' repeated delay tactics and failure to follow board procedures showed a disregard for the administrative hearing process and for the tenants' legitimate issues with their units and the property. The lack of good faith shown by the owner is very troubling." So I think what you're trying to do is extremely important. I originally sent my notice to Repair Restore Services in June of 2015, and the reduction didn't start until June of 2016. So, and then there were all kinds of problems after that, which is not really related to this. So I think that the reduction should be retroactive to, I mean, I think that third thing is so complicated, honestly. I know you guys are trying, but I think it's not workable. But I could see that, and I also maybe think it's not fair to the owners, but I sort of think it maybe should be retroactive to the date of the petition or possibly even the date of the inspection, which might be an alternative that property owners might also be more willing to kind of go with. I'm concerned about 4004A, if I understand it correctly. If the problem is corrected before there's a hearing, then there's no reduction at all. So theoretically, someone could still delay the first hearing. I know of a case going on right now that filed in January of 2018. They didn't have their first hearing until October, and
Sorry, is this an active case?
Yes.
Yeah, probably you shouldn't tell this, but you shouldn't. Refer
I'm
to
sorry.
this. Yeah.
Okay, there have been cases that I've heard about that might, before the first hearing, they might delay it for a year. So, okay.
Okay, I have Mr. Westcott. Thank you for
Yes.
that. That was very relevant personal testimony. Do you, when you filed your notice to your landlord, did you wait 30 days, or was it a much prolonged process because your landlord was dragging you down the chain, saying that they were going to resolve something when it wasn't resolved?
Well, there were times that there were things that were told that were going to be fixed, but in my case, it was very stressful. So the answer is I didn't file the petition in 30 days after I gave the notice, but it was probably within 60 days.
Okay. I
that.
appreciate your willingness to be, compromising in your proposal, saying, what works for both you and the landlord.
And I
So
really
thank
think
you.
that the issue I mentioned about, not having any reduction if they're, if they fix it before the hearing date is a serious
No,
problem.
I thank you for
Okay.
that comment. Thank you. We do not have any further public comment. Thank you for our speakers. Commissioner Foster, you are in the queue, so please go ahead.
Thank you, and thank you to both of our speakers and staff for this exceptionally clear narrative, taking us through one possibility, another possibility, showing both of their potential pitfalls for both parties. One would favor landlords and one would favor tenants who chose to engage in delay tactics on either end. And that is clear. So I agree with what Mr. Westcott said. It's a coincidence that he brought it up. I had written it here in my notes to speak to tonight as well. I am completely comfortable, first, let me say, with the third option. It absolutely splits the middle. This body already publicly deliberated and heard from a public hearing and voted on unanimously on the construction-related decreases being retroactive to the date when it could be established that the reduction in services was being experienced. Everything upheld that to this point. This is mirroring that exactly. It's also mirroring what we, the benefit of the doubt that we give to landlords, that before they finish the process, they have actually remediated the problem. They get credit retroactively to the date they fixed the problem, not the date at which the hearing officer certifies that they fixed the problem. So this is an equity mirroring that's very clear. The only change I would suggest would be under existing regulation 4004 subdivision A. My proposal is for the case in which 6 months to a year, let's say worst case scenario, like this gentleman's scenario, a year goes by before the first hearing is set. All those 12 months, let's say the hearing officer does find that these things were all deteriorated or whatever it is, these housing services were reduced for which rent was being collected and paid, but they fix it right away after that finding, and so then there's never a rent decrease. If you dated it in that case from the originally scheduled hearing, that would seem to me to at least go back to before any stalling tactics or legitimate stalling, legitimate absence reasons on either party's part. It would at least go back in the case where if there was a delay in getting everything resolved, but then they fixed it that day, I believe that remedy would fix that eventuality. So my proposal would be, I'm supportive of the staff report and of option 3 with the amendment that 4004 section A would be corrected to the originally scheduled hearing.
Thank you for your comments. I'm going to entertain some comments from Commissioner Duran.
Thank you. So I'm just trying to look at this in pragmatic terms and I guess always the hope of the way things should be, right? And it seems to me that if there's a problem, the parties talk it out, they find a resolution, and everyone lives happily ever after. I know that doesn't always happen, but that I think is the goal that I would strive for. So I think, in fairness, that if there is a problem, and in many instances only the tenant would know that first, there would be a requirement for the tenant, of course, to tell the landlord. And I think that it would be reasonable to assume that there would be a reasonable amount of time within which the landlord would be able to rectify the problem, acting in good faith. Now, what we're talking about are the situations, what we're trying to protect against are the situations when people don't act in good faith, and which is the reason for the regulations to ensure that people are acting in as best faith, or I guess in good faith when they're not willing to work in good faith. So is there an option that would seek or would resolve the way I look at things. I mean, maybe it's alternative 3 with the caveat of what Commissioner Foster mentioned, that there is a period of time. What was it that you said? Right when the hearing was set.
What I was saying was, right now, no matter how long the hearing process takes, if it looks like it's about to be favorable to the tenant or it actually gets ruled in favor of the tenant and then they fix it that day, there's never a chance for the rent decrease to actually be realized by the tenant, even though during 12 or 6 or 3 months they've suffered, the hearing officer agrees that they have dealt with the lack of an amenity. They never, ever realize the award because they fix it the next day. So my proposal was to go back to the originally scheduled only in the event when the landlord does fix it immediately after the finding. Only this is only addressing that this part of the staff's report is only addressing one small possibility. Let's say a hearing goes forward, they fine for the tenant, they get a decrease, things go 6 months before they fix it. The landlord comes, applies, says, I fixed it. They go out and verify that the landlord fixed it. And it's retroactive to that repair date. It's somewhere out in the future, right? The tenant's gotten several months of decrease, let's say, before the landlord fixes it. This caveat that I proposed is only in the event when a landlord maybe they don't delay anything at all. Maybe it just takes the time it takes. But if at the end of a 3 or 4 month process, the hearing officer does find that yes, this was broken, and yes, the parking space was gone, and yes, this and all these other things you've been living without, but you've been paying your full rent for. But then right now under our rules, after the date the hearing officer finds that, it's only the next rent date when it goes into effect. So the tenant has gone all those months having proved that they were in fact paying for something they didn't get. But if the landlord in this particular case fixes it the next day, they never, ever, ever realize any decrease, even though it was found that they were perfectly entitled to one. We're trying to remedy that by making it retroactive to, in option 3, the decrease from when the tenant gave the landlord written notice, subject to the caveat that they proceed right away, right? And that's the case here.
And I think that's my point. It seems option 3 doesn't reach my vision in the sense that it's retroactive to the point the landlord received notice. I think that there should be a reasonable time in which the landlord can reach that goal. And if I'm missing the point there.
But what would it be? Are you proposing something?
I'm open for suggestions. I don't know if 30 days would be the standard bearer. It seems like that seems to be the case in other situations. But I'm just thinking in terms of fairness for both sides.
I believe it already is 30 days.
There'd be a reasonable opportunity to cure.
If you're my landlord right now, and I talk to you about it verbally for a few weeks, and you don't do it, so then I know that the next step is I have to write it down in an email or a letter and give it to you. You have 30 days before I'm allowed to start the process.
Okay.
I would think to my opinion, that's the curative time.
Okay, so I'd like to say something as the person who requested this. I have a couple of comments, and then before I do, I assume that should we take any action tonight, because there's only 3 of us here, we have to have all 3 of us agree, correct? Okay, thank you. So, I mean, I think the reason why I initially brought this forward, and similar to the comments that Commissioner Foster made, we know that we rectified this process for construction-related decrease petitions, yet there were still tenants in the community who were continuing to express to me, and I think others on this board, that landlords are incentivized to extremely delay the decrease process, because they know that the decrease is not going to, the process to remedy, because they know that the decrease is not going to go into effect until such time that a decision's made. And I think that is not equitable. And here we're trying to protect both landlords and tenants, and we're doing things in a way that is fairly enforcing the law. To me, I think incentivizing a prolonged period is not, curative for these for the landlords or the tenants. So in any event, we also want to make sure that we're doing this in a way that's fair, that's easy to enforce, that minimizes the administrative burden on our staff, but also is something that easily can be explained to the community. And I think that, to me, a very clear, similar to what Mr. Westcott said, a very clear date. And when I read this, I mean, I think alternative 2, calculating the decrease from the date when the tenant filed the decrease petition, is a quite clear date. I think it achieves my objective, and I don't want to speak for the other commissioners, that we are, putting a more fair process in place to the date that everyone was made aware of the problem, which is the date when the tenant filed the decrease petition with us. I also think that I do think that it further incentivizes a quick resolution. I know that I was asking you why you thought that this would incentivize the landlords to prolong. I think I'm clear on what you were saying. I still think that alternative 2 is the cleanest alternative here. And I also think that I'm in favor of alternative 2 with a repeal of 4004A, because I think that, like Mr. Westcott so clearly told us, this, for some people, this is a multi-year process. And if the landlord cures the reduction before the hearing date, yet it's been a year that the tenant has been without services, I think that there needs to be some sort of remedy for that. I don't think that that is equitable. So therefore, I don't see that this clause is needed, and I would like to strike it. And that's kind of where I'm leaning right now. And Mr. Lewis has a comment.
Thank you. Yes, I just wanted to be clear that staff is not recommending any of these 3 approaches. I
Sure.
want to be clear that there was no intent to.
Although you're not recommending option 1.
Right.
Correct.
We're not recommending any of the 3, but option 1 is unrecommended. But between options 2 and 3, as I mentioned in the staff report in my oral presentation, option 2 is by far the easiest to administer. With option 3, we often have cases in which tenants give landlords 2 or 3 or more notices about 2 or 3 or more problems, that as they go through their process of talking with their landlord, or once they embark on the process, they think that there's X, Y, and Z other things. And so it does create the problem of having different dates from which to calculate something. So it is logistically problematic, option 2. The biggest problem with option 2 is not, although I believe that there is some incentive to delay that's in there. The bigger problem, it was not that. It's just that staff understood the board wanting to capture as much of the period as possible, and that doesn't do that.
Sure,
That,
I get you.
Yeah, so it wasn't that staff didn't favor that. It's just that staff did not understand that to be where the board was seeking to go, and that was the only purpose for it.
And that is correct, because when I brought this up, I did say I wanted it to be the date that the harm occurred. And since then, I've heard from the community. I've done a little bit of research, and then legally speaking, what I think is the most enforceable, I've subsequently, developed a more nuanced approach. And as I said, just stated, I think option 2 is the cleanest approach here. Commissioner Foster.
Okay, so there's two issues I think we haven't reached consensus on yet, and we may yet. And if we don't, we'll just continue talking about it next month. That's okay too. The only thing I would say before I finish up my thoughts are, so back to 4004 subdivision A. The key part of it, and I don't think I was clear earlier. A decrease. I'm reading from staff report on page 7. A decrease petition is dismissed altogether upon proof that the problem has been corrected before the hearing date. Now, look, the vast majority of these cases, I'm sure, are reasonable, and both parties are just reasonably disagreeing, and they get together eventually and are incentivized to fix it up. I think Any regulation is for the worst case scenario so that we protect the most people from anything that's not in good faith. And so whether the process takes 1 month, the hearing takes 1 month, or it takes 7 or 12, the decrease that's awarded, if one is, never goes into effect until about a month later.
Right.
So the reason I'm proposing just for this caveat of any of the proposals, because 4004A is independent of the staff's 3 other suggestions. This is separate from that. So I hope we can at least reach consensus on the fact that, let's take Mr. Westcott's old case, for example. If he waits 12 months, no matter why it's 12 months, and it is found that all of those things were truly deficient and he was overpaying for 12 months, let's say this particular landlord sees which way the wind is blowing and goes and fixes it after 364 days of dealing with this. It's in the present law, it is automatically buy if they just see which way the wind is blowing, and in the worst case bad apple scenario, do this. So if you go back to the originally scheduled hearing date, that at least something is corrected, or that at least it's retroactively given back to that date, if it so is proven. You've erased the incentive to unnecessarily delay and get away with correcting it at the last possible second and never having foregone any of the rent that you were collecting. Was that clear as mud?
I don't agree with that, actually. But
Why?
so are you still speaking?
Go ahead.
No. So first of all, question for staff: what's the average time from after which a petition is filed to when the hearing's actually set? Like the first hearing, not a delay. Or could you just say, just roughly guessing?
I'd say it varies so much depending upon how long the mediation process,
Right.
how long the parties are willing
Right.
to engage in the mediation process. Sometimes a time schedule is worked out when the repairs will be made through that process. So it varies greatly. I don't know that we have an average number. Do you know, Ms. Nalabov?
And wouldn't you say that in some of these mediations, you're going back and forth and back and forth and back and forth to try to set up a time for all the parties? There might be a delay and potentially coming to the mediation and having to reschedule it. I don't know how it works here, but, having run the county's, mediation program, both in court and in the community, I would say that I found that to be happening quite often. Would that be the case here? Yes, I'm seeing nods. So again, I agree with you. I think a majority of our landlords are good, and I think that we're going to resolve this. But and maybe it'll only be a month that there are these conditions. But then for those cases like Mr. Westcott referenced, where there's an unreasonable delay, I think that we can't say we have to strike or amend 4004A because. There could be a significant period with which there's a reduction in services and this person's not being, made whole for that.
That's exactly what I meant. I think we were just misunderstanding.
Yeah, but so are you ready to strike this? 4004A.
Which sentence are you striking?
Oh, I want to strike all of Clause A. I want to delete that. Which I think it was alluded to in the staff report, correct? Staff recommends that the board may retain the provision, but the board may repeal it if it values making the tenant whole more highly than it values incentivizing the quick resolution of problems.
Okay. We were misunderstanding each other both in the same direction.
Sorry, okay. So, I don't know that I agree wholly with Stephen's reasoning, but I still want to strike 4004A.
I see. Okay. That was a little confusing for both of us. Now I think I see what you're saying. Public, bear with us. We got to get this right.
Do we want to hear from Mr. Lewis, who's in the queue, while you look at it? Okay, Mr. Lewis, thank you.
I just wanted to remind the board that because this is a regulation, it often happens when the board adopts a regulation that's doing something that has not done previously, that as it goes through the process of living with it, it discovers that the regulation needs to be amended or tweaked or added to in some way. And it's important to remember that the board doesn't have to necessarily anticipate every possible wrinkle in the first instance. It can tweak it as it goes if it finds that it needs to.
Would you be saying that we not deal with this tonight and think about it again next month?
No, I was saying that whatever you do, don't worry that
it's a living document.
Right,
Yeah,
don't
we
worry
can make
that-
changes future.
Right,
Yeah.
it's not like a charter amendment.
Right, exactly. Okay, thank you for that clarification. I believe Mr. Drawn would like to make a comment.
I'm sorry, I just wanted.
Oh, sorry, go ahead.
The board understands, right, that the recommendation is it wouldn't be adopting the regulation tonight. It would be setting a public hearing for next month with. Okay, great.
Thank you. But what we don't know what we would be setting a public hearing on if we can't agree. So thanks. And we still need 3 votes, correct? Yeah, great. Commissioner Duran.
Well, after all that, I don't know that I'm at a point where I can come to consensus on this tonight, because I think that there's still issues that we're not in sync with, and I'm still not comfortable with fully understanding the reasons why both of you would. And I'm not
Tell us
saying-
Tell us how you're feeling.
Well, no. Well, what I am doing that, and what I'm saying is, I don't have a clear understanding of either of your positions on taking out 404A. You say that you're.
I wasn't proposing to take it out. I was proposing to change the timing.
But you were proposing to take it out.
Yeah, I don't think it's necessary.
So there's the issue, and we're not going to have 3 of us decide, because unless you 2 are coming into some kind of consensus, then
Well,
it doesn't
let's
matter.
go one more. Let's go one more round. So I was proposing that if a landlord decides for any reason, okay, I'll fix it, right, prior to the tenant experiencing the benefit finally of the relief, because one step backwards. Early in the staff report, it says that when we issue a decrease, it's because someone's been collecting rent for something they didn't give.
Right.
Understood.
So if a hearing officer is going through, like, let's say it's months of mediation and months of a hearing because of schedules, and maybe it's a reasonable problem with schedules, even so, all those months are going by after they have filed, that they are still experiencing the loss of the amenity, and they're still paying for it. So if you delete A, you're actually making the tenant really whole all the way back to, well, isn't that right,
No,
counsel?
We're saying it's at the time. I'm proposing it's at the time that the petition's filed, is when you can take the decrease back to.
I think I see the issue here, for at least for me. There's 2 issues. 4004A is separate from the date we would choose
Correct.
for the regulation.
Correct.
So I think there's some crossing of the
Yeah.
streams here. So if you forget about all the 3 proposals staff has made for possibilities for this new regulation, and staff was proposing leaving 4004A in, potentially just as it is. All I'm saying is that if you go through, pick any one of the first 3 or leave it as it is today, the law currently as it is, for when the decrease goes into effect. This is separate. This is just simply saying that if at any point in the process the landlord decides to fix it, and the hearing, it really did need fixing, my proposal was simply to go back to the first hearing date as a compromise between going all the way back to when the complaint was made to the middle ground. Something that's my proposal anyway. The date of the first hearing to the date of when it was fixed would still be awarded because they still suffered the lack of the amenity.
No, I think we're getting confused.
Yeah, I think that's where it's twisted.
So, I mean, I could try to explain this, but I don't know.
Maybe staff needs to separate out these 2.
Well, I mean, I think that they're separated. Well, Mr. Lewis, do you want to say something, or do you want me to try to explain this? Okay. this is how I'm seeing it as two separate issues, right? Okay. So we didn't necessarily ask for you to opine on 4004A. However, I think that there is like a residual effect of 4004A on the decision that we're going to be making about this, right? So we wanted to have a more equitable process for a decrease. I think that, as I've stated on that front, alternative 2 seems to be the fairest approach for both landlords and tenants.
Why?
Be-
You can make clear.
To me, I think, you know, you're giving the landlord that 30-day period to remedy the issue. You're still incentivizing some sort of resolution between landlord and tenant. However, instead of waiting for a decision, which could take years, as in Mr. Westcott's case, you're saying that the decrease will go into effect from the date that the petition was filed. And I think that, you know, everyone's had clear notice when the petition is filed that there is an issue. It's not, you know, ambiguous as to what the date of the harm. It's not going to be hard to enforce by looking at the actual date that the notice was given to the landlord by the tenant. You're actually looking at a physical date when something was filed with the rent control board. So I think that's very clear. I think it gives everyone the opportunity to rectify the issue, and if it's not been rectified, we're going to the date that the tenant filed the decrease petition. However, that is a problem for me if you still have 4004A in effect, because 4004A says that even if it takes a year to get to the hearing process and this tenant has not had an amenity for a year, and at the day before the hearing the landlord decides to fix that problem that has not been in that amenity that has not been in place for a year, the tenant gets nothing. So even though we've done a process where, excuse me, I shouldn't use the word retroactive, a process where we're putting the decrease in effect to the date that the petition was filed, it's not going to remedy anything if the landlord still decides to fix it on the day before the hearing, and therefore for a year or for a year and a half, that tenant is not going to be made whole. So I don't think that leaving 4004A in the way that it is currently structured gets at, to me, at a full resolution to the problem like I had asked for last month. So if we are wedded to keeping 4004A in, I think that we should say, if at any time prior to a petition being filed, a petition for rent decrease being filed, a landlord indicates a response that they've corrected the condition, then there will be no decrease. But I don't think that we can leave it at the date up until the date of the hearing. Does that make sense?
Got it.
I'm not explaining very well,
Well,
as eloquently as Mr. Lewis, but that is my reasoning.
I think I got it. You're in the Q&A.
Yes.
I'm cool with that.
All right. So, okay. So you have these moments of lucidity, and then they're so fleeting with me. Back to the muddle.
Are you saying that you're not lucid right now?
Yeah, I'm confused again.
No,
Okay.
Do you have the
That
mens
your
rea to
moments
make a
aren't.
decision here?
No, here we go. This is it. What you said made sense to me, and I think what you're saying also is if we go with what you proposed in preferring alternative number 2, that would make 4004A
Unfair.
in conflict with
Yes.
with what you're saying.
To me,
and therefore,
yes.
And therefore, one or the other should go. And in your estimation, 4004A should go so that it's consistent with the alternative number 2, which is to your liking. Is that
Correct. Like,
looking at that?
irrespective of the date of the hearing, the person should still be made whole from the date that the petition was filed.
Got it.
I don't know how we're going to enforce this. We can, I mean, I assume that we have some sort of enforcement mechanism if we don't actually have a hearing. But there was a petition filed for rent decrease, and then the services.
Well, we would have to have a hearing. You can't do anything unless there's a hearing and there's a decision.
Right. So okay. Right, because you're still going to have to go to hearing, but then the landlord's going to assert that the remedy was, or that the services were already put back in place. But you're going to have a hearing, and you're going to award a decrease depending on the period of time which there was no service. Okay.
Okay. So wait. So I think I still have the floor.
So,
I think Stephen wants to say something too.
All right.
I just wanted to clarify that subdivision A simply requires the outright dismissal of the application. That's all.
Correct, which I don't think is appropriate.
Okay. So I think that option 2 gets to the point I would try to make originally, but who knows? And it was that there is notice, there's a reasonable time to fix, and then with the idea that people are going to be working together in good faith to come to reasonable solutions, there then is a deadline by which to push that along. And I am in agreement with Chair Terosis that you know, we have to find some date to say, okay, this is your cutoff date to act reasonably and get results. And I think, having heard this go back and forth and around the corner and back, that Chair Terosis's date is as good as any, and I think it's fair and it's reasonable. So I am on board with that.
Oh, okay. Just to clarify, you're on board with option 2 and either an amendment or a striking of 4004A.
Yes, because I believe that it would then be inconsistent and incongruent with option 2. And my answer was
yeah. I mean,
was
I can.
yes,
I mean, to
because
me,
it
like
would
I
be
said, we can
correct.
either strike A or we can just make it the date that the petition was filed. Yeah. So it aligns it with what we're trying to do in this new regulation. Okay, sorry. I think.
But then would that be superfluous? I mean, would that be necessary?
I think
to
it just makes it fully clear.
Have it stated
Whatever.
twice?
I mean, I would think council would bring something back that makes sense for us based on what we've asked for in option 2.
Yes, the board doesn't have to decide every detail of it. You just have to
Right.
tell staff the direction that you want to move in. It's not at all uncommon for a public hearing to take place over a couple meetings. So it's not as though you have to nail down the language of the regulation now. You just need to tell us
Yeah, I have a
what direction you
proposal.
want to
Okay,
move in.
sorry. I think Commissioner Foster wanted to make a comment. And Mr. Westcott, are you looking to make another comment? Okay. Okay. He's like, get done with this. All right, Commissioner Foster.
I was really, really in favor of alternative 3, but I, have been somewhat convinced by my other commissioners that alternative 2 is also okay and serves the purpose of what we are trying to achieve. It's just a differing intensities or different, frequency, volume. We could, because there are only 3 of us here and we have not heard from our other 2 fellow commissioners, we could say bring back a more fleshed out alternative 2 with 2 possibilities for 4004A. With a couple, like a deeper explanation of 4004A and the implications. Because if you delete it completely, then what if a landlord does correct it during the process? Then there's no provision for that. So maybe we need to let staff further explore 4004A as a secondary issue within this same thing. Because I think we're pretty clear on what choices 1, 2, and 3 provided, and we've kind of decided, the 3 of us at least, to move ahead with option 2. But I don't think we're clear on the ramifications of either amending or deleting 4004A, and I don't think there's any rush. It's in the history of this board, it's been very typical to take 2 and 3 and 4 months to get through something as important as a major rule change. So my proposal would be that we declare that we've reached consensus on moving forward with item 2, noting that the public or the other members of this board could change our minds and, tweak option 2 somehow next month. And then also at the same time we're considering that, simultaneously consider ramifications of changes to 4004A. Is there any interest in that?
I still think we can set it for public hearing.
Yes. No,
Okay.
That's what I'm saying.
Yeah. I mean, I'm interested. I think that I don't need further study on what the ramifications of 4004A.
Well, I do.
Okay. Yeah. No. That's fine. That's fine.
Then
I'm just-
I won't be able to agree to consent tonight.
No,
if
that's fine.
Because I'm not ready for
So you're proposing come back with language for option 2
Uh-huh.
for setting for public hearing and potential options with an explanation for 4004A.
that we could act on
Okay.
if we all agree and the public has weighed in at the end of next meeting.
I agree with that, Commissioner Drawn.
I'll agree with that too.
Okay. Do we need to actually take a vote, or do we just say that we have 3 people who have agreed to set this for public hearing for option 2 and potential options for how to handle 4004A? Is that sufficient, Commissioner, or excuse me,
Yes.
Mr. Lewis? Okay, thank you. With that, I believe we are moving on. We have a very lengthy agenda with very juicy things on here, because I always love the annual report, which I don't know that there's any agency that has more database decision making here than the Rent Control Board.
Statewide required reading.
I agree, and I think that, you know, if people want to look at the impact of rent control, this is it. So I'm excited. All right, 12B. Yeah, without further ado, the annual report.
Thank you, Chair Terosas
Thank you.
and Commissioners. Good evening. So I've been doing this for a few years now, and I'm afraid that too often it's sort of the same story. They're different numbers, but kind of the same story. But we try to come up with a couple of new pieces of analysis this year that I hope will complement what we've done before. Of course, this is the annual report that has 4 parts to it. It's the status of controlled rental housing, the impact of market rate vacancy increases, the impact of the Ellis Act, and then there are some departmental overviews. So with that, I will move right on. I think one thing that should be noted, there's a 52-page report, and even with that, it's hard to consolidate all of the work that the agency does during the year. 2018 was a particularly busy year, both for the agency and for the board. You considered a lot of high-profile issues and made some new regulations that are going to impact a lot of people. So 2018 is probably going to be a memorable year in many ways. There was, of course, the issue of the possible repeal of the Costa-Hawkins Rental Housing Act, and while that didn't happen, it sure brought a lot of people, and I remember that and other issues filling the chamber last year, and so that was good to have so much public input and comment. So this report is really more about the regular business of the agency, the day-to-day work that we're doing, and it overviews what the status of controlled housing is in Santa Monica. So at the end of 2018, there were 27,445 units subject to rent control. That was a 70-unit increase over 2017. The variation is generally due to exemptions that have been granted or lapsed, or waivers that may be granted to owner-occupied units, or Ellis activity. This number is far below the 39,000 units or something like that that were registered when rent control began in 1979, but the difference is really due to exemptions that have been granted to single-family dwellings, to units that we don't consider controlled because the rents have been decontrolled after 1996 with tenants in separately sold condominiums and single-family dwellings, and then various use exemptions. And those account for nearly 10,000 units that are no longer under rent control. As always, we use we break down the controlled units by city area, and you can see in the map on the upper left what the percentages are of units in the various areas. Obviously, Unit G has the most number of units, 22%, and Unit C downtown has far fewer units. And this year, I was able to use the city's geographic information system to map the properties that are subject to rent control. So there are 3,503 properties at the end of 2018 that are subject to rent control, and they are kind of color-coded on the map to the right by the city areas that they're in. And this is the first time that I have ever seen a map of where all these controlled units are.
Can I ask a question about that?
Yes, yeah, anytime.
Sorry, I don't want to interrupt, but hopefully you feel we can we have this be interactive?
Absolutely.
Okay. The GIS map, I'm really excited about this. I really get into these. Can we have this as like a story map on our website? Or who created the GIS map? Can it be interactive on our website so people can easily access it?
We can certainly post the image on our website.
So we can't like actually zoom in and see where each of the units are on the map?
No, you can't really. I mean, the city's, well, Ms. Ghana may have something to say about it, but the city's system allows you to zoom in very closely.
Yeah, I'm pretty familiar with GIS.
Yeah, and it is accessible to the public, but it's not possible, as far as I know, for us to store these maps. But maybe if we spoke with the Information Services Department, that they might be able to make that available to the public.
This is very fascinating, especially given our districting situation right now.
I was going to say what Mr. Costello said, that we currently provide information about all controlled units to the city for the kind of Excel type file that they provide. And I'm sure we could create a layer of within the GIS where we could identify by address the controlled properties. It changes a bit with exemptions coming and going. But so we might exclude 2 and 3 unit properties or something, but we can work on that. And it also might be something that we can incorporate into our new property rent tracking system.
Yeah, I think having like a shape file for this and like a map layer and some sort of GIS, either database that the city has that could be publicly accessible would be great to put on our website to the extent that we can. Anyway, thanks. Sorry.
And I think
interrupt.
this is really just a start for us because. Again, these are really just the properties, and one point on the map, might be 500 units, in the case of the shores or something, but another dot might be just 2 units.
Yeah, so, fabulous. Thank you.
Yeah. But it is clear from the map that there's obvious density differences in the different city areas. Downtown, very few controlled rental units, rental properties. I think it's interesting that even in Area G, which is a large section of the city, really about half of that section has no controlled units. Those are generally probably R1 single-family dwellings. But that creates a whole lot of density kind of between Montana and Wilshire. And then you see, like in the Sunset Park neighborhood, most of the controlled units are along the Ocean Park Boulevard corridor and not much in the interior areas or the center areas. So the chart on the bottom left, the pie chart, just breaks down the controlled units by unit size. The light blue area on the right are 1-bedroom units, and they and the 2-bedroom units in the dark blue comprise about 82% of all the controlled units. There really aren't a whole lot of studios or a whole lot of 3-bedroom or larger units. And it's just nice to keep this in mind as we look at the numbers going through, how many units are affected in each category. So every year we chart out how many units have gone to market rate and how many long-term units are remaining. So there are 25% of long-term units remaining. Those are units that were rented before January 1st of 1999 and typically have rents that are based on 1979 or 78 plus general adjustments. And then market rate being all the units that have rented multiple times since 1999. Last year, there were an additional 505 units that were rented at market rate for the first time, and 393 fewer long-term units. So we also have a couple of other categories up there, which are 0 MAR units, restricted, and Section 8. 0 MAR units are those units that have no rental history in our system and are most likely owner-occupied. The restricted units are restricted either because of an eviction for owner occupancy or for an Ellis withdrawal, and they've come back within 5 years. Or the Section 8 ones, obviously those are governed by the federal contracts, and so we just separate them out from the long-term and the market rate units. So there were 8 fewer units in the Section 8 or Housing Choice program compared to 2017.
Do we know why that is?
Well, it's really that those tenants vacate. So if a Section 8 tenant vacates, and a new tenancy is registered for that unit.
And it didn't have a voucher attached to it?
That's right.
Okay.
So, yeah. So we will check with the housing division and make sure that the date that the tenant actually vacated and
Yeah, and I just want to make sure, because we have we have laws against source of income discrimination in Santa Monica, that we're making sure our landlords are not discriminating based on the Section 8 voucher or other subsidies.
That's right. And I do have to admit that on figure 9 of the report, it's not the chart shown here, there is a typo just talking about the fee waivers that have been granted. And the 2017 amount is listed as 651, but it should be 631. So I would like to correct that. Is it 631 as it is shown? I'm sorry, 631 as it's shown there on this chart. Okay, so that's like yeah. Yeah. So I'd just like to mention that in the report itself, there is another chart that shows the change in the ratio between long-term tenants and market rate tenants since 1999. So then we look at kind of what is the distribution of these market rate units. The chart at the top shows in the two top bands units or properties where half or more of the units have been rented at market rates, and you can see that it's a very high percentage across various unit sizes, from 4-unit buildings to 15-unit buildings, and they comprise 90% of the controlled housing stock. So 90% of the units are within this range here. But it's kind of true for larger size units. You'll see few properties with all market rate units, and you see none with no market rate units. So the small band at the bottom are properties that have not recorded any market rate units, but they represent a very small share, I think just 3% of properties with no market rate units. And then we looked at where are the market rate units by city area, and since we know on average citywide at 71% of the units are at market rate, we can compare that to the percentages in the various city areas. Area C has the highest percentage of units that have gone to market rate at 77%, and Area D has the lowest at 63%. But most of the others are pretty close to the average of 71%. For Area C. And the map to the right is just to give you just to remind you where those areas are. And this is why I feel somewhat like a broken record, because every year I come and we talk about how the median initial rents set for all bedroom sizes has set new records. Last year, when we presented the report, the information that we had showed that there was actually a slight reduction in the median initial rent for studios. But when we got all of the information in, it turned out to be flat compared to 2016. But this year it has gone up another 5.7%. So the easing that we thought we saw, if you look at the table under 2017, the percentage increases were much below those percentage increases for 2016. But that was temporary activity, and you can see back now in 2018 we've had increases of 5.7, 4.1, 4.9, and 7.5%. In dollar terms, the studios, the median price of studio in 2018 was $100 more than it cost in 2017. One bedrooms were pretty close at $95 more, and then 2-bedroom units went up 150, and 3-bedroom units went up 300. So the rates have gone back up, and we'll see if it continues. But as we set record new highs every year, just don't know how strong the market can go. So we like to compare what the median MARs are for long-term units versus market rate units. First of all, just across the city, long-term unit median MARs are 957. The median MAR for market rate units is twice that or more, 2,213. And then the median for all controlled units is closer to the market rate amount because there are more market rate units, so it's 1,913. And then the chart on the bottom shows by city area the difference in median MARs. And in just about any city area or in any unit size, you will see a difference that is typically double or more of what the long-term median is. So it's pretty much across the board that market rate units are renting at 2 or more times the rate or the median MARs of the long-term units. So even though many of the units have gone to market rates, it doesn't mean that rent control is not benefiting them. Once they move into the unit, their increases are limited to the general adjustments. And this chart shows for 1-bedroom units how much below the 2018 initial median rent that tenants who moved in these various years are paying. So as an example, in 2000, I better look here because I can't see that far. So 2000, a tenant who moved in 2014 is today paying $474 less than the $2,395 market rate. So if owners were able to increase all rents to market rates, they wouldn't see that savings, but the value to rent control is clear to even market rate tenants, and obviously the longer they've been there, the difference between median rents each year makes a greater difference the further back you go. There are also charts in the report for studios and 2 bedrooms and 3 bedrooms. Oh, I don't know why that happened, but so this is a this is a chart of affordability, and it for the 19,562 units that are currently at MAR, we look at what was the rent for that unit in 1999, and then add the general adjustments and show what the median MAR would be today for those units, and then compare that to the median MARs for market rate units set in 2018. And we look at what the income would be required to rent such a unit. Prior to vacancy decontrol, a household making $46,000 a year would be able to afford a 1-bedroom unit. Today, that same household would need a 6-figure salary, so $1,750, the household income of that.
Can I just make a comment? I really hope that everyone is taking note of this, because I think this exemplifies, the crux of the issue post Costa-Hawkins. I hope that this isn't lost on anyone. The extreme, what is this, like a 200% increase, over a 200% increase here since 1999, which is, pricing people out of this neighborhood. And that's why, preserving our rent controlled units is so important. So thanks for that, and I hope that the Santa Monica Daily Press is watching.
And I don't know if they had this, but they mentioned the income required, the difference. If you look at also, if you consider that the area median income for the Los Angeles greater metropolitan area is $69,300, no family making the median income could afford to move even to a studio in Santa Monica. A studio would require an income that's 32% higher than the AMI. The charts on the bottom and I guess up in the upper left represent the affordability of units by various income categories. So in 1998, the chart on the left, you can see that the units were generally affordable to people at various income categories, low, very low, moderate, even extremely low. But in 2018, that has really shifted, and it's 84% of sorry, look at that. Actually, 96% of units are affordable only to households making moderate or higher than moderate income. So that's 110% of AMI or 110% or greater. And you'll see on the chart on the right, the extremely low category is just gone. So there's nothing for anybody in the extremely low category. I would also mention there was one other typo in one of the tables in the report that I would like to correct. It just had to do with the very high number of higher than moderate units that are units that are only available to higher than moderate households.
Okay, fine. I'll wait till later. Thanks. No, I'm really appalled, and thank you for doing this.
All right, now this chart shows the years that tenants occupied controlled units, so when they moved in. It does exclude the zero MAR and the Section 8 and restricted units, so it's slightly different than the pie chart that I showed you earlier. But you can see that roughly 30% of tenancies have begun within the last 3 years in controlled units. And if we go back to 2011, you can see that more than half of the tenancies began since then. So there is a lot of turnover, and again, these tenants who have moved in since 2011 are paying those record high rates that you saw earlier. And tenants, there is turnover because tenancies that began no earlier than 3 years ago created 38% of the vacancies last year. So a lot of people are coming and going, and obviously from this chart, a lot of Santa Monicans are new to Santa Monica, and about a quarter of them are people who have lived here for 20 years or more. So moving on to other good news is the Ellis Act was no, it's first, before I even begin this section, I just have to give a shout out to a couple of people on my staff, Karen Evans, who is our Ellis coordinator, and Morena Zelaya, who is an information coordinator, and she did an amazing job this year of consolidating information that we've had in various databases to give us a very clean picture of what's going on. The chart on the top in light blue shows the units that were withdrawn in any year, and the withdrawal may have begun an earlier year, but it was finally withdrawn in the year shown. And then in dark blue are re-rentals of units. So since, now moving to the table below, since the Ellis Act came into being, 3,113 units have been withdrawn from the controlled housing market in Santa Monica. 891 of those have been returned, so that's 28.6% of those units that have come back. And while that seems like good news, in many cases these units are coming back at market rate rents. So the owner may wait 5 years and then rent the unit at market rate. So I don't have the breakdown, which I think we can do at some point, but in any case, the balance is 2,222 units that have been withdrawn since 1986 and 466 properties. There are also some properties that are redeveloped and then offered for rent within 5 years, and those become subject to rent control. So there were 15 properties and 258 units where that have come back, which kind of offsets the total number of units that were withdrawn under the Ellis Act. But it doesn't really negate the impact on many households. I mean, really, if you look at the top number, the 3,113 units, those are tenant units that had to be vacated because they were evicted. Some of the units were vacant at the time that the Ellis occurred, but in any case, 3,113 units have been affected. So last year, there were 20 properties and 97 units that received notices of an intent to withdraw. The map on the right shows in red where those properties are. The blue ones are properties that are also currently withdrawn. In addition to the 7 properties withdrawn in 2018, there were 10 properties from 2017 that were completing their withdrawal in 2018, and they had 35 units on them. So the combination of the 27 units that were withdrawn, the process began and ended in 2018, and the 35 units that started in 2017 and were withdrawn in 2018 is 62, and that happens to be the same number of units that were re-rented. So if you look at the previous chart, you'll see for 2018 we have an even number of units that were withdrawn and those that were re-rented. Then we thought it'd be very interesting to look at what impact Ellis Act withdrawals has had by city area. We have always done this in the annual report, but only for the current year. This looks at all withdrawals since 1986. So if you look at the third column over, which is share of units ever withdrawn, it would appear that areas E and G had the greatest impact from Ellis activity, with 22 point something % of units of all Ellis activity being in those city areas. But then when you account for units that were returned to rental, the 891 units that were returned, then look at the share of units currently withdrawn in the second to last column, it's clear that area C has had the greatest kind of net effect of withdrawals, and then sorry, I guess E is a little bit higher, and then C.
Can I ask a question?
Yeah.
So I know that the city of LA has an interactive GIS map where you can track Ellis eviction, or excuse me, Ellis removals. Is it possible that we can also put this on our website interactively?
There's an organization that has mapped our
Is that the
Ellis
Coalition
eviction.
for Economic Survival? Is there a different one?
No,
Okay.
I can't remember the name of it right now.
The
but it's-
anti-eviction mapping
Yeah, the
project?
anti-eviction.
That was
Yes.
done through the Matthew Desmond's work, I think.
The
potentially.
anti-eviction mapping project. They
Okay.
did our map originally, and they've updated it periodically.
So we have an online map somewhere.
Yes.
But I mean, I feel like if we owned it and had it on our website, that'd be good. My other question is when you were, the status of the properties receiving notices to withdraw, you wrote on 17th Street, the first one, 4 of 14. Is that, am I understanding that correctly? 414?
Yes, that property has 2 buildings on it.
Oh,
And to withdraw an accommodation, there has to be at least 4 units in the building. And so the owner is withdrawing just 1 building on the property.
and is that building predominantly vacant? Like, I just don't understand this 4 of 14. Are we saying that 10 of the units were vacant?
No, the owner is only served notices of intent to withdraw on 4 of the 14
Okay, and
units.
then because they're two, okay, interesting. Even though it's it's like bifurcated, I guess.
Yeah, because you can withdraw accommodations, and accommodations being a building with 4
Yeah.
or more units, they chose to just withdraw the 1 building.
Okay, but there are actually 2 physical buildings. It's not like they're just choosing.
That's
to,
correct.
Okay.
You cannot choose
Yeah,
units.
right. Okay,
Yes.
thank you.
One of the units was vacant, and the other 3 resulted in evictions. And those were all market rate tenants who were being evicted.
Okay, thanks.
So just to finish this, so then we looked at the number of units that were currently withdrawn relative to the number of units that are in any area, because as I showed in the very beginning, there's a big difference in the number of units in each city area. And when we look at it that way, we can see that Area C certainly has been impacted the most, with 32% of units withdrawn. And Area D had the lowest number of, or lowest percentage of units withdrawn, fewer than 3%. And Area E, which is generally between Wilshire and I think Santa Monica, Colorado, I'm sorry, Colorado, yeah. Colorado has lost over 9% of units. So those 2 areas are certainly impacted very heavily by LSAC withdrawals. Once a property is withdrawn, we get information from the city's planning department about reoccupancy permits or use permits, and so we can find out how the withdrawn properties are currently being used. As you can see, a lot of the usage is for residential use. So beginning with apartments in the upper right, and condominiums, single-family dwellings, and family occupancy or non-rental residential makes up about 2/3 of post-Ellis use. This year we did separate out units with no activity, so no permits have been filed for those properties, and we don't understand what the owner is intending to do with that property. Condominium use is obviously the highest use. 27% of the units are either condo or condo mixed use. And then single family dwellings would be the next largest use at 22%. So we decided to map these as well to see if there were any discernible patterns. And in some cases, there are, for example, the condominiums and condos mixed use are generally in Area G, much fewer in, say, the Sunset Park neighborhood, just a little bit downtown. These maps sort of speak for themselves, and so we didn't put a whole lot of commentary in on them. So we have these categories as well as single-family dwellings. That activity seems highest in the Ocean Park neighborhood, not so much in Mid-City. And the no activity or family occupancy is kind of spread, all around the city. So moving on to the departmental overviews. Traditionally we've only presented the public information department, the hearings department, and the legal department, but there really is a 4th department of rent control that deserves a lot of credit, which is the administrative department, and I think next year I have to rectify that. But Ms. Condon and her team do an amazing job and are just provide so much support for all of us. And it's critical, but I guess it's going to go unsung tonight. So my Department of Public Information has a lot of responsibilities, obviously meeting with the public and answering the phones and their email questions and handling the registration of tenancies and ownership registration, working with the administrative department. We look at plan checks and demo permit review to make sure that controlled units aren't being removed or demolished. We do eviction monitoring, exemption monitoring, and we publish all the newsletters and websites and website content, social media stuff, this report. And we also work a lot with the other city agencies on various activities that are all outlined in the actual annual report. But services, or the demand for services from us is very high and is consistently high. We had 13,486 public contacts last year. That's obviously well over 1,000 a month. It keeps us very busy. But I think the big news this year was the increase in our website usage. Yes, it went from, I think our total website hits went from, I think about 86,000 in 2017. 87,000 up to this 139,900.
What do you think that was attributable to, and can we replicate that and continue to engage our constituents here?
Well, we're certainly trying to do everything we can to get people there. And certainly the online filing of tenancy registration forms has had an impact. Looking at website usage, about 55,000 hits were to the tenancy registration page. So that accounts for a lot of it. But we think that it could be also because our process now is faster to register the tenancies and put them in the database, that owners may be checking back with us to find out if, you know, their information has been updated.
That's great. Thank you for your work.
Yeah. And then, well, that's enough about public information. So on to the hearings department. As you can see from the chart in the upper left, the number of decreased petitions filed last year took a big jump, up to 97 petitions filed. I was looking at the stats in the appendix of our report, and decisions were issued, I think, on 43 cases last year. And so although it's just a number, it's really something to think about, like what it takes to get a decision out, and just the volume of petitions that are being filed with us just creates a challenge. I think former Commissioner Flora mentioned that it's a good thing when these go up. And that means that people know that we have a remedy for them, and they're making use of it. As has been the case in previous years, the mediation has been very effective, and 37% of the decreased petitions were fully resolved last year.
Can we have a goal, maybe like a strategic planning goal of increasing that percentage? What do we know?
Every effort is made. Well, I
know, but like an actual concerted effort. What is the has this percentage increased?
It has been increasing, but it's slightly lower than last year.
Okay, sorry,
I think last year we were at I can tell you 49% of decreased petitions were mediated and resolved. Okay,
I feel like just based on my limited knowledge, we should increase this number. That's just my personal observation. Thanks. Sorry.
Yeah. I think in every case we attempt mediation. Some people are not open to it.
Right. I just think that in most of these cases, there's going to be a continuing relationship between the landlord and the tenant. So that to the extent that we can resolve it amicably, which I think I'm obviously preaching to the choir, like we want to be able to do that. So thanks.
Right. Mediation is certainly more effective with excess rent petitions. So 77% of those have been resolved through mediation. So that's very good. Yeah, that's a very good number. And then the two boxes on the right show that 62 and 63% of the petitions that were filed by market rate tenants. So it's not just the long-term tenants who are coming to rent control. It's a lot of the new people as well. Newer people. Moving on to the legal department. There are only so many interesting graphics that you can create from litigation, so there's not much here for them. But you know, as you know, they were very busy last year drafting regulations, and you know, you passed some important ones like the change in how surcharges can be passed through to tenants, and then property tax related surcharges. So there were 8 regulations that were approved by you last year that were drafted by the legal department, and 5 resolutions. And of course, they do all of the exemption application staff reports, like you saw tonight. But this slide is really the kind of thing that I think a lot of people are interested in. These are buyout offers by city area and by unit size. If an owner negotiates a buyout offer with a tenant, they are required to file a copy of that with us within or after 30 days, but within 60 days of it being executed. And so we report on the information we have from those buyout offers. There were 63 buyout offers filed last year, and the average amount was $54,611.
Can I just say something? I'm very skeptical of these numbers. I just like to flag this for everyone. I think we need to do more to be enforcing registering the buy. I mean, in our next year here, because to say that there are 3 buyouts in Wilmot makes 0 sense to me. I know more than 3 people have told me personally. So we need to think collectively, I think, to address this, because it seems extremely low to me.
Mm-hmm. Yeah, we are trying to get the word out. I think in our most recent newsletter, we included an article that tells owners that they do have to file those with us. But I think it's also interesting that the amounts of the buyouts have gone up considerably over 2017. The 2017 average was 35,800. And so this is obviously much higher. And in a couple of areas like Area A and F, you see average buyouts that are into the 70,000s. And since those are averages, you can imagine how high some of the buyout amounts were. And there were pretty good numbers. There's about 23 buyout offers in Area F to get that average. And of course, these are all well above the standard relocation amounts that must be paid to tenants when they're evicted through a no-fault eviction, like for an Ellis withdrawal or an owner-occupied eviction or removal. And with that, I thank you, and I'll take any more questions you like, but I would like people to know that if they would like to get a copy of this report, it's available on our website, where we'll probably put it up Monday, I guess, since we generally like to present it to you first before we put it up on the website. We have printed copies in the office. They can always call us or at any time contact an information coordinator or an analyst with questions. And I guess finally, this is something that the board does typically forward to the city council to report on the status of controlled housing. So I assume you'd like to do that.
I assume we would. May I?
Yes, absolutely. Please proceed.
Thank you. I mean, I made a joke at the beginning that was not a joke. This is required reading up and down the state. I get commissioners from Berkeley and I mean, just people from all over. People from New York. Everyone wants to see this data for both landlords, property developers, speculators, tenants rights advocates, everyone. Santa Monica is a unique microcosm. sort of a little closed system with a diverse population and a diverse property value spread. And it's a really super easy to digest, condensed, incredibly laborious, I'm sure, to put together and make it so easily digestible, but you do it. You do it every year, and you are to be commended. I have a couple questions. In the appendix on page 52, it says tenancy rent registration forms 4,725. Is that indicative? Is that a raw number that we could assume is, for instance, the number of units that turned over, that got a new tenant?
For the most part, I mean, yes, but they may not all have been in 2018. So owners are required to register new tenancies within 30 days of the start of the tenancy.
So January notwithstanding.
But yeah, at times people are late with their registration, so we do get registrations for prior years.
But the same is probably true for things this year that aren't being filed until next year, or
Right.
So,
right. And
but that's an interesting stat to look at, like the number of units that turn over. And I remember in years past we've had a figure that I've tossed around a lot that said the average turnover post a certain year is every 3 to 4 years. Do you find that that's still the frequency now with which newer tenancies turn over?
Well, looking at recent data, yes. I mean, we haven't always studied that, and I think we continue to look at that. But as I said, the 38% of the vacancies, the units that were filled, the vacancies that were filled in 2018 were from tenants who moved in, I think, since 2016. So there are a lot of people coming and going.
Yep. And another question, exemption staff reports prepared and reviewed, there were 22. Can you remind me or refer me to where in the data how many owner occupancy exemptions we granted and how many units that are decontrolled now that represents for the year 2018?
What page was that?
I'm asking him where it is.
Yeah, we did not. Well, let's see. I don't know if there is a section on use exemptions on page 47.
Sorry, I normally would give you my questions like that in advance, but I just thought of it.
So there were 12 properties granted owner-occupied exemptions in 2018. I was going to say I don't think we entered the actual number of units. I mean, each one of those properties has to have 3 or fewer units, typically 2 or 3. But I don't know exactly how many that was.
It's funny. I recall. I mean, I was chair that year, for most of that year, and I seem to recall it being agendized every single month, almost without exception, and sometimes 2 and 3 per month. Like tonight, we granted 3 exemptions in one meeting. So to only have 12 in the entire year would seem low.
There were a few months last year where we had no exemption applications, which was somewhat unusual. Because you're correct, we usually have 2 or so per meeting.
Which would reflect a number more like 20 to 30.
But we did have a
So
few.
I would like to come in and maybe talk to staff about some just further data in that category. Because in the beginning you did highlight that it represented quite a bit of over the years of the units that are no longer under rent control. So I'm just curious what the trends are over the years of owner occupancy.
Right. I do see that in
Changes,
the appendix
isn't
there were 22 staff reports.
That's what made me think
So
of
I
it.
think 10 of those probably didn't make the grade. So only 12
Interesting.
exemptions were
I have to go back and look
granted.
at that.
Yeah, I know.
But
It's not really fleshed out in here. Oh, it's probably the only thing that's not really. Otherwise, everything.
We don't have the number of units, but it does say that there were 22 applications filed. 8, the board approved 8, denied 3, 5 applications were pending at the end of the year, and 1 was withdrawn. So that's the summary of those applications filed.
Okay.
One thing I can add is that through the exemption monitoring process that we do,
Oh yeah, how many?
and that has
how many
really
lapsed?
picked up. I think that's also in there, but I think it's 28 or so were found to have lapsed last year, mostly through that exemption monitoring process. And Mr. Mortarzai has been very helpful with that.
That's a really
And-
important program.
And when these exemptions lapse, it may be that the new owner
Also lives there.
reapplies.
Yeah, sure.
So we've discovered that the old owner has moved off, and so you might find more exemption applications being filed.
And I noticed several of those in the past year. But that's a very vital program. Thank you so much.
You're welcome.
Any further comments?
Thank you
Okay.
very much.
Thank
Right.
you.
You're
This
welcome.
was fabulous, and I'm going to be using it in all my future discussions.
Yes, and I just want to thank Mr. Costello for his very, very hard
Woohoo.
work on this. As you can see, it reflects the work of the agency as
Yes.
a whole, but Mr. Costello and his team, and primarily Mr. Costello, really pulled it together. So thank you very
Thanks
much.
for pulling it together.
Thank you.
Thank you. Yay. Okay. So moving on, this is another exciting topic, 12C. This is a resolution of the Rent Control Board urging the City Council to impose a moratorium on the development of new projects in the Pico neighborhood that have previously been occupied by rent-controlled units until the City Council completes an evaluation of zoning restrictions on properties from which units were withdrawn from the market under the Ellis Act and completes an adoption of the Pico Neighborhood Plan and consider increasing affordable housing in lieu fees for projects that replace rent-controlled housing as put forward to us by Commissioner Phyllis. Do we have any sort of report on this item? No. Okay, we do have a speaker on 12C, and we have an Ellis Raskin. Thank you very much for waiting this long. I hope you found this to be a very informative evening, and we appreciate your comments. And yes, I did see Mr. Raskin's email. Thank you.
Yes, indeed, it has been a very informative evening. Good evening, Commissioners. My name is Ellis Raskin. I'm a resident of the Pico neighborhood. I live in a rent-controlled unit in the Pico neighborhood.
Yay.
I'm also on the city's Urban Forest Task Force, and I'm an environmental and land use attorney, and a portion of my work involves enforcing environmental statutes that require cities to disclose the environmental impacts of evictions. I strongly urge you to adopt this resolution tonight. It's very important, and I thank you for taking up this important topic. As you saw from my email, I also wanted to talk to you about another dimension of the loss of rent-controlled units, which occurs through the redevelopment process, which is the introduction of covenanted affordable units. The problem, and I know this is a step removed from rent control itself, but the problem with those covenants is that they have sunset provisions, which end generally the affordability restrictions after a period of, say, 55 years. So to the extent it's possible to do so, I urge you to add language to the resolution to urge the council to look at ending these sunset provisions, because it will severely burden our community in 55 years or whenever those sunset provisions kick in, because we'll see a sudden drop in the availability of affordable units as soon as those sunset measures come into effect. So, again, I know it's a step removed from rent control itself, but it's a dimension of the loss of rent control that needs to be seriously considered and hopefully addressed either in this resolution or in a subsequent resolution. So thank you very much for your time this evening, and I'll leave it at that.
Thank you, Mr. Raskin. I actually have a question. So typically these affordability covenants are pertaining to deed-restricted affordable housing, of which rent control is not. So I would just like to say, although I understand what you're saying, I don't necessarily know that this is within our purview. However, I also know that a lot of these deed restrictions are tied to bond financing, which is expiring, and then the covenants have to be renewed. So I don't know that we could presuppose that a project would be able to refinance after 50 years. I know that that's obviously a affordable housing preservation issue, again, of which we are sympathetic to but don't necessarily deal with here. I don't know if you have anything to comment on that.
I realize that it might be beyond the purview of this board, but to the extent that it's a consequence of the loss of rent controlled units, I think in that sense it's something that this board might be able to consider. Since it's within the broader context of the resolution, I wanted to talk about it tonight and bring it to the community's attention.
No, thank you. We appreciate your work, and thank you. I don't know, does Mr. Lewis have anything to say about us being able to add anything or do anything about this?
Well, you certainly couldn't if you wanted to approve this resolution tonight, because the resolution as drafted is what it is. But I also agree that any party who has that concern should take that concern directly to the city council because it's not really within the rent control board's purview.
I would also state that we just had this came up yesterday, I think, related to our preservation tactics here in the city. I think that you definitely should continue this discussion and make sure that we are using our affordable housing trust fund dollars to preserve deed restricted affordable housing. And we are supportive. And I'll speak for myself. I am supportive in that effort.
And just to add on to that, you may also want to attend a housing commission meeting because they definitely deal with this issue. And I think they meet on Thursdays. You've been to, well,
I think the next one is for sure next week.
Next week.
I believe it's on the 21st or 23rd or something.
Yes.
20, yeah.
But
Housing
no,
Commission.
thank you for your very analytical approach. We appreciate it. I don't see any further public comments. So seeing none, do our fellow commissioners want to make any comment? Commissioner Foster.
Yeah, we discussed this at length last month, and it's simply a recommendation that City Council sit up and take notice of our opinion on the effects after rent-controlled housing is removed, and I think we move it forward. I would propose to do that.
I'll second.
Okay. I guess our clerk will call for a vote here.
Commissioner Foster?
Yes.
Commissioner Duran?
Yes.
Commissioner Trosis?
Yes.
Motion carries.
Great. Thank you. And Ms. Condon and Mr. Lewis, how are we going to be transmitting this to City Council in our normal fashion?
we transmit it to them with a memo, and we send it to all of the city council members and the city leadership so that they also have it. The city manager, the planning director, the city attorney's office.
Okay, I hope that they are responsive to us, because sometimes I feel like we just send it over there and then we never hear back. So,
Well,
yeah, I know. So I guess it's
but it's
incumbent upon us to follow up.
Read it
Yeah.
and use the information that's provided.
Sure. So I want to make sure that this is important to us, City Council. Thank you. Okay, this is very exciting. We have a mid-year budget report for fiscal year 18-19. I know all of our friends here care much about that.
Well, I'm going to make this report relatively brief because the written report itself is quite detailed. And this is just an opportunity at mid-year to sort of look at where we are and where it looks like we'll be by the end of the year. And as you've seen from the written report, I'm really just going to summarize that our revenue projections have been right on pretty much. We've done, Mr. Mordezai does an excellent job working with other people in our department on collection of past or registration fees from previous years. And it looks like, although we had projected collecting, I can't remember exactly what the number was, we're going to probably collect about 20,000 more in past due registration fees this year than we had originally anticipated, so that's good. As I probably mentioned in the past, that pool of funds is getting smaller and smaller because we've collected a lot of the past year's fees. So that's a good thing. So overall revenue, we think we will come in about 20,000 to the good by the end of the year. With respect to expenditures, and for this, I would recommend that you take a look at the chart that's attached to the back of the report. Yep. It looks like overall we will be right on target with our expenditure projections, coming in a little to the good of about $2,500. However, we do have some shifts. We have projected savings of significant amount of $77,000 in our permanent employees line, but that is offset by what we are projecting will be an over expenditure in the as needed employees line. And that's attributable in part to when we did the budget, we knew that we would have several retirements within the hearings department. We didn't know exactly when those retirements would occur, so we budgeted those positions as with the status quo. Ultimately, the positions have been filled with people at entry-level salaries, so there has been some savings in the permanent employees line. As well, we had a staff member out on a medical leave for the first 4 months of the fiscal year, and her what she was being paid by disability or workers' comp during that time, so that was some salary savings. And we have one of our information coordinators who will be on a leave for the next 4 months. We've approved a leave for her, and she'll be returning, but she's on a leave for the next 4 months, so there will be salary savings there. Those are offset by the increased cost in our as-needed employees. We've had retired rent control staff people, hearing officers, and staff attorneys, as well as some city attorney employees who have helped us when we have more petitions and hearings than the permanent staff can handle. So we've used those people more than we had anticipated. You noticed in the annual report that we talked about, or in this report I think we talked about, we've had one construction case with more than 24 tenants participating in this construction decrease. We've had 20 to 25 hearings on that, and there's a volume of documentation going with that. So we've hired an as-needed paralegal to assist us with the organization of that documentation. We also have a agency that's transcribing those tapes for us, so that will assist the hearing officer in preparing that decision. So we've had some additional costs, but the savings in both the permanent employees line as well as savings with respect to our medical insurance costs and our retirement contributions will offset all of the increases in the as-needed employees.
Can I ask you a quick question about that
Sure.
before you move on? So back in the annual report, we talked about Todd Flora's good thing, that people are taking advantage of services and processes that are available to them. But if the number of petitions filed is going up, should we expect that the category of using as-needed hearing officers and things like that are going to continue to stay in demand for that line item?
Well, you'll remember that we added a hearing officer in the budget 2 years ago. Because of retirements and things, we've had sort of fluctuating staff. We've hired very good new people who are jumping on board, holding hearings. It's our hope that those people will be able to handle the petitions that are being filed. But it's possible, we won't know for some time, but it's possible that if we have this sustained increase in petition filings, that we might need to use as-needed staff. Additionally, I anticipate we will continue to use them in the future. But as we have a full staff of hearing officers and they're all trained, hopefully we will be able to meet the demand with the hearing officers that we have. We have used as-needed people to do the mediations, and it's ultimately our desire that that is handled in-house. I think a year from now we'll have a much better sense of whether we're going to be able to handle the mediations in-house. We had a long-term retired person who had helped us with that. She terminated her services. We have a new person that's helping us with that. She's very effective, doing a good job, trying to move things very quickly and get things, agreements reached as quickly as possible. So we value mediation very much. We've seen the success that it has, and as Chair Tarosa said, these people have ongoing relationships, and it's very important to try and, have a very positive relationship going forward. So we are always looking at whether or not we will need additional people, but I think we will continue to use as-needed people into the future, hopefully not at this extent.
Okay, thank you.
And then in the second category of the budget, supplies and expenses, everything is pretty much in line with what we've anticipated, other than I'm going to mention we are anticipating over expenditures by the end of the year in the other costs line. That is for the coverage of the Rent Control Board meetings and election costs. We have not yet gotten the election costs for the 2018 election. It takes the county a while to provide that information, and then the city clerk will tell us what our share of that is. It's possible that it could be more than the amount that we had originally allocated for that cost. I think that was about $35,000.
Why does it vary?
Because
Shouldn't that be kind of a fixed, predictable
No, it depends
cost?
upon the number of measures and
Oh,
how
so it's a
many
shared
seats
burden.
we're filling. Yeah, and
Okay.
the school board, I mean, there are a whole
Gotcha.
lot of people, and it just are a whole lot of different pieces that go together, and it varies from year to year. The other thing was we paid for some of last year's coverage of rent control board meetings, the cable coverage. We got a bill for last year in this year's budget, so we're a little over on that as well. The primary over expenditure is in the area of legal expenses. We have outside counsel helping us with 2 matters, and we believe most of that expenditure has been expended, but ultimately we're anticipating approximately $50,000 of over expenditure in legal expenses. Savings from other lines will cover that, but the board also has a designated fund that we have reserved and identified available for legal expenses if we need to. So,
Can I ask a question about that? So you're saying outside of this adopted total budget, there's some other sort of fund we could use to pay for this?
yeah, we have a cash fund, which is our reserve that we have, and we need it to cover earned but unused vacation time, any other agreements that we have to pay that are available to employees when they retire. So we retain a certain percentage of the budget. So that's a general cash reserve, but we also have a designated cash reserve for legal expenses of about $42,000.
Okay.
But we don't anticipate needing to draw on that this year because it looks like we'll have a balanced budget this year. It's just things have shifted within the budget.
What do we think the timeline is for resolving these, Mr. Lewis, these legal expenses?
Very short. The case is now in the Court of Appeal, and oral argument is set for the 10th of April.
Okay,
So
cool.
it's almost over.
Are we going to go to that? Are you going to go?
I will be going, yes.
Okay.
I don't know that we will go, but
No, I'm kind of interested. That's yeah.
It's a
No,
public
let us
hearing,
keep
so-
us posted. Okay, thank you.
I'd also note just that although in this year that was a high expense, we've seen figures like that to the good in previous years because we rarely use any, even a tiny fraction of our legal expenses.
That's fine. And in certain circumstances, obviously it warrants this. So thanks. How are we doing on the PERS pay down?
Well, as you'll recall, in addition to this operating expense budget, when the board approved a budget, there were a couple of expenditures that were in the non-operating expenses. Those were the database replacement project, which is underway, and that's not reflected in the operating expense budget. And the other was the PERS loan that the council had given a loan to the board of about $500,000 when they made a $45 million pay down of the unfunded liabilities. So this year will be making our second payment on that loan, and we have set aside that fund. It's encumbered for this purpose, so we have those funds to cover that loan as well.
Okay, great.
And so that essentially, I'll just mention the capital outlay section of the budget deals with building renovations, reserve system upgrades, and computer systems and office equipment. We are anticipating expending all of this. These are will be ancillary costs related to the database development project, some other software and hardware that we might need to buy that is apart from the contract itself, but we allocated that money and we have it here, and we're projecting that we will expend it this year. The database improvement project will carry over into the next fiscal year. Probably it will be at least a 2-year project. Hopefully we'll have the replacement of the system in place later this year. Bless you. By the end of this year, but we will be continuing to work on enhancements into next year as well. So basically, it's a balanced budget, and I'm happy to answer any questions that you have.
I'm satisfied. And again, I know it's really challenging. Balancing the budget is really challenging. We really appreciate your diligence and your fiscal responsibility. That's important. So thank you.
All right, and I also, of course, want to thank Ms. Noseworthy for the work that she does on the budget. She and Mr. Gwynn work very hard on this, do a great job of tracking expenditures, and I want to thank them both for their work on it.
Thank you, Mr. Gwynn. Any comments? Yeah, sure. Go ahead, Commissioner Foster.
I just want to make sure, Mr. Costello, jumping back 2 items to the annual report, he said, "Oh, and I'm sure you're going to direct everybody to move." Do we need to formally say, "Please give this to council"?
No, we will do that.
All right.
I mean,
I didn't know.
indicated
If
that
you needed
wanted to.
actual, direction.
We will do that.
Okay.
Yeah.
Excellent. Okay, so it appears that we have come to the end of our agenda. Is there a move to adjourn?
Motion to adjourn.
Second. All those in favor?
Aye.
Aye. Thank you.
Thank you. Thank you.
Stephen.